Hello everyone, this is Sachin Sawant. I'm live now. I'll take the questions on the channel. It's a member only live. Only members can ask any questions. Others can put the questions in the comments. I may not be able to address them today. So there are a lot of questions on the channel. I'll start taking them. So 4 days ago is onwards till today. So first come, first serve. Okay. Firstly, thank you very much for my wife. Give a shout out to my wife for this lovely tea that she has prepared, and it will keep me going for a while now. Okay, fine. So the first question that I have on the channel, let me see if everything works fine. Okay, I see everything is working perfectly. All right. Hello, 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 hello. Yeah. Okay, so the first question on the channel that I have is I'll try and summarize the questions as there are many and try to answer them. So the question is, if someone who is on a new entrant visa, obviously their salaries will be less than 38,700 after the change of the increased salary. Can they sponsor the dependents? So the sponsoring or being able to sponsor or not able to sponsor dependents depends on the job code. If you are in one of the job codes 6145 or 6146, care worker or senior care worker, then you cannot sponsor your dependents. That is how I would put it. Other things don't matter. So next question I have is Gary. So the question is, you applied, Gary Pari. You applied for the skilled worker application in August 2023, but you have not yet enrolled your biometrics. You got your course through the agent or something, and the agent said not to attend the biometrics. I'm not sure what the problem is. You need to investigate the agent and the employer whether that's everything is genuine or not. There are a lot of frauds happening in the UK, so just be careful of that. But unless you enroll your biometrics, your application cannot be processed further. Secondly, about bringing in dependents, yes, if you do enroll your biometrics and everything goes through fine, you can bring your dependents because your date of application was August 2023, provided it was a valid application. Okay, I've answered that. So next question is Sheetal Jha. So you're on a graduate visa, valid until May next year, May 2025 maybe. My employer said they can only switch visa 3 months before my current visa expires. That is not true. Your employer is wrong. The graduate visa holder can switch to skilled worker at any time. So they don't have to wait till the last 3 months of the visa. Secondly, your salary is not 38k, so it's not meeting the 38,700 requirement. So will I still be able to switch? No. If you do switch, try to switch in May, either this May or the next May, because the rules for the minimum salary to 38,700 will be changing from 4th of April. If you do it in May, either this May or the next May, you will have to qualify as per the new salary requirements, whatever they are, 38,700, or you are applying for a new entrant or whatever that is. So the solution would be tell your employer to apply for a sponsor license if they don't have one. If they have one, apply for a allocation. If they don't have an allocation, then assign it to you and apply for the skilled worker visa as soon as possible if you can. So next question I have, if my course came before 11th of March, just 1 minute, I'm just checking that I am live properly. 1 minute. Okay, I am live. Fine. So that is my answer. Next question is about my course came before 11th of March, but biometric after 11th March. So yeah, So if your course has come, I think I don't care when the course came. The point is, if you have filed the skilled worker visa application, you paid the IHS and the visa fees, and you submitted your application on or before 10th of March, then you will come under the current rules. The biometric enrollment date does not matter. Then you can bring the dependents on the care worker job codes. So next, I am currently working in the UK. My salary package is below the threshold, 38,700. Right now I am holding graduate visa. So the question is, to apply for a graduate visa, do I need to ask my employer to indicate me as a new entrant? Yes. While assigning the course, in the course there is a field new entrant. They have to select this as a yes. It's like a right check mark, and that's how they tell the home office that you are a new entrant. That's how you apply for a new entrant course, and using that course reference you apply for the new entrant skilled worker visa. Contract will end. Okay, Mark John, you just have a comment about contract ending, and you will be applying for renewing the visa. Thank you for answering my question. Thank you very much for asking the question. And don't skip ads for informative channel. I'm not sure what that means. Okay, next question, Atul. My course is assigned. My job starting date is 3rd April. So work start date is 3rd of April. If I applied my visa before 11th March, okay, you can apply. My biometrics are done after 11th March. Yes. So that's the same thing I answered just before to the previous comment. The date of application matters. If it is on or before 10th of March, 11th of March, the rules change for the dependents of care workers. Then if you submit it on or before 10th of March, dependents can join or continue. Next question, 24 hours call expires, skilled worker course refused, blah, 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 blah. Okay, so the next question, 24-hour on call. Okay, so your question is, so this is a common problem that is happening. Individuals, they are on student visa and they try to, you want to secure your skilled worker visa. A student visa doesn't qualify for ILR. It's not a route to settlement. Graduate route is also not a route to settlement. So individuals try to jump directly from the student to the skilled worker, and then in between they want to jump ship back. So they change their decision. That is what has happened. You were on a student visa, you applied for a graduate route visa, you applied for a skilled worker visa, sorry, you directly went to the skilled worker category. Before a decision is made, you decided you want to apply for a graduate visa, now you want to change. So you submitted your graduate route application, that's called as variation legally, and you want them to consider the graduate route. The date of application of the graduate route matters. I know you have filed it, and then after that you got a rejection of the previous application, whereby by filing the graduate route you tell the home office that I want to vary my application from skilled worker to graduate route. Please ignore my previous application and consider this one. But the home office still went ahead and decided on the previous one. It is a mistake from them. I know you enrolled biometrics late or something, but I don't care about the biometric enrollment. The date of application is what matters. So yes, you may have to file an administrative review for that refusal and challenge it accordingly. It's not an easy job. Admin reviews are taking 1 year and more counting. So take a proper legal representation. They should properly explain it to the caseworker what has happened, what they should have done, what they have done exactly, and I think that's the only way to get it sorted. So as per the immigration rules, I can only tell you, as per the immigration rules, you are fine. They have made a mistake, they should have ignored it, but it's not practicable. When the caseworkers are looking at applications, also it goes to different teams. Graduate will go to a different team, skilled worker will go to a different team. When the skilled worker application was there, since you have not enrolled your graduate route biometrics, I don't know why you were enrolling biometrics, but yeah, anyways, you did the online application or something. So yeah, they would end up making a decision on the previous application because there is no connection between those teams or something like that. So there is that break. But you will have to file an admin review and get it sorted. Okay, do it through legal representatives. That's my advice. Okay, next question I have on the channel. My wife going to UK nursery. So your wife is coming to the UK as Ranjit. Yeah. So Ranjit, your wife is coming to the UK as a nursery worker for 1 year visa, At the end of the 1 year, when she files for extension, your question is, sponsor has to increase the salary to 38,700 minimum. Yes, they will have to go with the salary rates as per the new rules when she extends, or if she changes jobs at the end of that visa. Anytime after the change happens on 4th of April 2024. So she will need the new salaries subsequently when she is extending. Next question, I already in UK healthcare visa, can I bring my child? Yes, if you are already in the UK, Tirekat 4013, if you are already in the UK on the healthcare visa, you can still, so you are already in the current rules, you can still bring your child after March, after the change happens. I am applying to employer BIP states. Next question is, you already have a skilled worker visa, Khara 92, and you have ended the job. I think you have not yet got the 60-day letter or something. You are applying for another skilled worker, you are changing employer. What expiry date should I enter on my new skilled worker visa application? You can put any date. Sometimes clients put 31st of December 2024. So you can also put the 2026 end date of your previous permission end date. It really doesn't matter. You can go with the BRP end date, that's fine. Home Office understands it's not a relevant matter to the application. So next question, student. This is a confusing question. I'll try to interpret it as much as I can. They both are separate. Can student dependent go? Dependent one. Okay, so this is how I understand this question. If I'm not understood correctly, you can restate it in another comment. Jiva Hardy, that's your question. So I understand there is a student and there is a dependent on the student. If the student gets a care worker job code, care worker visa, after the change, after the dependents are stopped, on or after 11th of March, then can the dependent continue as a dependent of the care worker visa holder? No, they won't be allowed to switch. Remember that people are assuming that if you are already in the UK on a dependent visa, that doesn't give you any extra credit for being on the dependent visa, whether the dependent is inside the UK or the dependent is outside the UK. It doesn't change anything. The rules will apply the same way. This is very important. Someone who is on a student dependent, or let's say graduate dependent, they will not be able to switch if the main applicant is switching to the care worker job codes on or after 11th of March. Dependents are not allowed in that category. So if you are inside the UK, it doesn't change anything. You will have to leave the UK. Remember that. Next question. Can I get a refund of IHS fees? I'm willing to hear too. So the question is, someone is switching from a private sector to the healthcare sector. You are becoming a doctor in NHS. You already have a skilled worker visa. You want to get a refund of the previous visa. So yes, you can get it. Obviously, you will not be paying any new IHS for the new visa because you are in the healthcare occupations. So, but you will have to liaise with the Immigration Health Surcharge team. Google search for IHS refunds UKVI. That website will come up. Contact them and let them know. They will require your previous IHS reference and all, and they will process it after that. It will not be automatically activated to the best of my knowledge, because you will not be paying IHS on the new application because you are exempt. So that's how I understand it. But yeah, if they do it by themselves, that's very good. Okay. Next question, Mahasiddiki 8031. Basically, I'm worried about the new financial requirement for dependents. 20,000. So the 29,000, the financial requirement is for Appendix FM applications, family route applications. From 18,600, it will increase to 29,000. That will happen from 11th of April. It does not affect dependents of skilled workers. Your question is, does that 29,000 number affect dependents of skilled workers? No, it does not affect dependents of skilled workers. That is only for spouse visas or other visas, whatever that is, parent visas and all of that, under the Appendix FN, which is outside PBS. Okay. Next question. Do you know I'm eligible for ILR 10-year one? So the question is about you have been on three different categories of visas, whether all three of them qualify you for indefinite leave to remain on the long residence. The categories are intra-company transfer, yes, that qualifies. PBS, I'm assuming PBS dependent or PBS main. Yeah, PBS dependent will qualify you. Main also will qualify you. Okay, so and the third one, you are a student doing an MBA degree, even the student will qualify. So ICT, PBS dependent or main, and a student, all of them will count towards your 10-year, towards your long residence ILR on 10 years legal in the UK. Okay, next question. So Buddhika Priyadarshini, your comment is, thank you sir giving information. We are awaiting also the news for new rules. I'm not sure what new rules you are waiting for. The care worker visa that you commented on, those rules have already been published and they will go live on 11th of March. So just to note. Next question is, I wanted to ask regarding the financial requirement of independent skilled worker visa. Yeah, so the salary threshold for whatever that 29,000 does not apply. I already answered to Maha Siddiqui's previous question. The 29,000 financial requirement does not apply to dependents of skilled workers. Answered this one. So there are many comments that have been asked repeatedly. Please don't ask comments again and again. I do address all the comments. It just wastes my time reading through everything. It wastes everyone who is viewing this now live, or when you or anyone else is watching it afterwards, after it is uploaded. So please refrain from copying and pasting the comment again and again. I have one comment which is 4 times repeated, another one 5 times. I'm just wasting my time scrolling. So next question, absences for ILR no longer more than 80 days. Okay, the question is about, it is on absences for indefinite leave to remain on skilled worker visa. So the rule is 180 days in any 12-month cycle. You should not be outside the UK in the 5-year period. You are on the skilled worker visa for more than 180 days in total in any 12-month cycle. So the way the 12-month cycle is calculated is, it's a rolling cycle day to day. For example, today is 28th of February. If today is the date of application, you have to count from 1st of March 5 years ago till today. That is your 5-year block, and it's a running cycle. It's from 1st March to 28th Feb, from 2nd March to whatever 1st of March. That's how you have to look at the whole 5 years and different 12-month blocks. Anytime in any 12-month cycle, you should not be out of the UK for more than 180 days. Yeah, if you have any specific case, usually speak to an immigration lawyer, take details, take advice on that if you have specific absences or something like that. But that is a general answer I can give. How about in my case? Okay, this question is about, you are currently working on a skilled worker visa. Your employer sent me the application. I think your employer sent you the extension application. You filled it up and to renew your visa. So it may be an extension application, but your BRP is valid until 14th of May. Do I need to fill up now or after? You can fill up now because I think they are trying to trick me. Yeah, I don't think your employer may be trying to trick you by applying earlier. The only thing that they may be trying to do is, many big employers are doing that. Even we are advising many of our employer clients who already have individuals on the skilled worker visa, and they may require an extension to go up to ILR. So in your case also, since your visa is expiring in May, the new rules will apply to you when you apply for extension after the increase, after 4th of April. If you honor after 4th of April, when the salary requirement goes up to 38,700, your employer will have to give you that new salary. That is what they want to avoid. That's why they are trying to extend your application on the current salary. Okay. Next question I have. No live questions. Okay. Kedar, but I'm currently on PSW. What would be the minimum salary requirement for me to get sponsored after 11th April? After 11th April, if you are applying under the new entrant visa, your salary should be minimum 30,960. 30960. I have a different video on that. Graduate route holder switching to new migrant visa or something, that gives you all the detailed calculations and all, but just the answer is 30,960 would be the minimum salary. Can I open a foreign LLC while in the UK? Next question, Saida. While on skilled worker visa, I don't think HMRC stops you from registering any companies, but the only thing is when you are filing for an ILR, when your NI number is run by the caseworker, if they find some companies registered in your name, they may try to investigate further, saying whether you were genuinely working for your sponsor or not, or were you trying to work for your foreign LLC, etc., etc. If you have enough justification to prove otherwise, then you can go ahead and do that. But yes, if you are unable to justify that, they may refuse your application, saying you are not genuinely employed as a skilled worker with your sponsor, you are doing something else with your foreign LLC in the UK. So that can be alleged. So make sure when you're filing the ILR, if you do go ahead with registering that LLC, make sure you have enough evidence that you were still working for the skilled worker, your main sponsor, for the contracted hours and doing the main job properly. Next question, Ahmed. Okay, the same question again. The salary threshold to bring dependents of skilled workers has not changed. Only the financial requirement is increasing from 18,600 to 29,000. That does not apply to dependents of skilled workers. Okay, again the same question 5 times. Okay. 6141 job code, which is not a care worker job code, that has been restricted for the dependents, self and dependent. So you already got the visa for yourself and dependents, but only you are going to come after 11th March. So that doesn't affect you. Only the date of, if your date of application is on or after 11th March, then it affects you. If you already have the visas for yourself and the dependents, you are fine. You come under the current rules. Can I apply for UK's without certificate? Applying for skilled worker visa with a dummy certificate of reference number and asking the caseworker to hold, this will not apply for outside UK applications. Your question is, can you use that for outside UK applications? No, you cannot. It will be clearly refused as an invalid application. It is very highly unlikely that they would consider to hold an application which is filed outside the UK. There are no reasons. Inside UK, there are other considerations. Okay, this is done. Next question is, can one still bring his underage children for a student who is master's pending? So the question is about bringing a dependent child and you're studying master's till 2023. I'm not sure what do you mean by pending. The way the rules have changed for dependents for students, to the best of my knowledge, is anyone with a course intake of 1st of January 2024 or thereafter cannot bring dependents. I think if your course was prior to that, you may be able to, but check with your admissions office what is happening, whether they have put you on a new course or whatever the situation is. But that's how the immigration rules have been written. Any course intake that is from 1st of January 2024 onwards cannot attach dependents. With your specific case, I think you have some masters pending till 23, 24. I'm not sure what do you mean by pending, whether it was, if it was started before 1st of January, I think you can, but still speak to an immigration lawyer, get a proper advice and get it analyzed properly. Okay. So the question is, can we apply for EU settlement scheme if we came to the UK on skilled worker company law sponsor license? EU settlement scheme is completely away from PBS dependents or PBS applications. That is only for EU nationals or family members. Also, the deadlines have gone long past. Even EU nationals, if you do qualify, you should speak to an immigration lawyer. If you are an EU national or something, yes, you can speak to a lawyer and see if you can file a delayed applications. Almost 99% of late applications that are filed now are rejected as invalid. There are other options of challenging their decisions and all. That is possible, but speak to an immigration lawyer if you do qualify under the youth settlement scheme, and only then go forward with that. Yeah. Okay, same question. Question is, does employer need to pay ISC, immigration skills charge, for hiring someone switching from PSW visa? Yes. If you are switching from graduate route to skilled worker visa, then you have to pay immigration skills charge. But if you are switching from student to skilled worker visa, the employer doesn't have to pay immigration skills charge. That's how it works. If you have been working for your employer for over 19 years. Okay, this is a question, this is a common thing. You are already working for your employer, you may be on a graduate route or something, let's say, and let's say your visa expires on 31st of March. Your employer wants to give you a certificate of sponsorship. What should be the work start date? The work start date on the certificate can be the next day. Assuming your graduate permission ends on 31st of March, it can be 1st of April. So 1st April 2024 onwards can be your work start date on the certificate of sponsorship. Next question, when employers get license approved, do they get allocated number of undefined costs? No. If nothing has been asked, they will get zero costs. The employer has to put in the application, sponsor license application, how much cost they want, and only then Home Office will consider and either give them all, none, or some, whatever that is, depending on whatever is the case that the employer has presented, business expansion, any evidences they have given, funding, etc., whatever they have proven. By default, sponsors don't get allocations. They have to ask it as a part of the application. There is a field where they write down how many allocations do you want for undefined, 1, 2, 3, 5, whatever that is, or 0. Yes. So whatever they've asked, if they've already asked, yes, they can go ahead and that has been approved along with the application, the undefined cost, then yes, they can go ahead and assign it to you and you can file the skilled worker application. Why DCOS taking too much time? This is a common question everyone is asking me. I don't have a straight answer for this. Even UKVI is not giving any answers. They themselves don't have an answer. They are very much bombarded with many applications. There are many risk sectors they are assessing, mainly this care sector, which is like almost 80% was fraudulent. That's what we are also seeing. Even Home Office knows that. So they are checking each and every application from that care sector, and they are checking other sectors also, builders and all the salaries which are very much on the borders. I've seen that they come with those long checklist of questions every time a DCOS is requested. But under normal higher paid jobs, usually 40,000 and above, or 50,000, or CEOs and all of that, usually IT related jobs which are highly paid and all, we are getting DCOSs quite easily. I've got many times, even last week I got one in 3 days or so. So that is fine, but only on these high risk sectors they are trying to bifurcate it. That's what Home Office has confirmed. They are splitting the applications into high risk sectors and all. The high risk sectors are taking more time. They are asking questions to the sponsors, checking everything is fine. With care workers, they have a special questionnaire that I just got. I discussed it on some other video, where they are asking current employers that you have on as migrants, have you recovered any visa fees for them? Are you going to recover any visa fees from this particular migrant? Etc. etc. Those are completely new questions. They just don't believe you. They are asking like everything. Yeah, so that's why the courses are taking time. And they send a questionnaire, then the employer replies back, and that takes time. That sits in the queue, and because of the changes also, there is a lot of applications that are being filed. So that's the other side of it. So there is no straight answer for why there is a delay. Thanks for the info. We have 1 year fixed bond for nationwide. The next question about financial requirement for spouse visa, which is 18,600 now, increasing to 29,000 from 11th of April 2024. So cash savings, if you want to use cash savings, you have fixed bond from nationwide bank. A bond may be treated as an investment product. Usually investments like shares, derivatives, or whatever you have, then you have to liquidate them as a part of the application and show evidence that you held it 6 months back and you hold it now, and the funds in your current bank account. That's what is the normal process. But usually speak to an immigration lawyer, show them whatever the bonds are, what are the terms of it, are the monies withdrawable. A bond, to the best of my knowledge of commerce, it is kind of a loan to someone, whatever that is, to the bank or to the company. So it may be treated as an investment product and not pure cash. So you may have to liquidate it. That's my first opinion, but still speak to an immigration lawyer and then they may be able to advise you properly. Next question. Soma has asked this question several times. What's the minimum salary threshold to bring dependent on skilled worker visa? There is no minimum salary threshold to bring dependents on a skilled worker visa. How do you contact me? When you go to the channel information page, there should be a website, visa-solutions. Go on the website, you should have a contact form, you can fill that up. So just to note, we only provide free information on this channel. Out of this, any specific advice about your own case, you have to book a paid consultation. When you send the contact form, someone from the office will send you the details of booking the consultation. Next question. I have applied visa cost letter 1 month ago, but I'm still waiting. My cost is delay. Okay, cost delays I have already discussed just 3 minutes back. Okay, so just refer to that. What can I do if I'm unable? Okay. Okay, so now I have answered as many questions as I can. I may go live on Friday, most probably. I'm not sure exactly, but yeah, so I've tried to answer as much as possible. I've come up to 19 hours ago, and thank you very much, everyone.